Major ruling involving the Second Amendment.
Major Supreme Court ruling.
The Supreme Court has just issued a major ruling.
It's a case that legal experts will be watching closely when it likely heads before the justices.
Concealed carriers already juggle enough rules as it is, but 2026 is not coming in quietly. Some of these changes hit way harder than most folks realize. The dates are locked, the penalties are real, and a couple of states are rolling out moves nobody expected this soon. What's going on, folks? This is Tommy from Locked and Reviewed. Today I'm breaking down the gun law changes landing in 2026 that every concealed carrier needs on their radar before they walk out the door strapped. Before we dive in, do me a solid, smash subscribe, tap the bell, hit all the buttons down there. You don't have to, but it keeps this train rolling and lets me keep putting out real gun talk without watering it down. All right, back to work. Why concealed carriers might lose sleep in 2026. When people talk about big gun law years, they usually mean something loud, like the 1994 assault weapons ban or the Bruin fallout. 2026 is different. This one is a stack of quieter changes that hit you in the wallet, in the courtroom, and at the gun counter if you're not tracking the details. Federal rules, sentencing guidelines, state-level experiments, all landing in the same 12 to 15-month window. And concealed carriers are right in the blast radius. Federal changes concealed carriers can't ignore. At the federal level, you've got the NFA tax stamp dropping to $0 on suppressors and short-barreled rifles starting January 1st, 2026. But don't get it twisted. The ATF registration grind is still fully alive, and the felony penalties for unregistered NFA gear did not go anywhere. On top of that, the U.S. Sentencing Commission rolled out new guideline changes that took effect November 1st, 2025. Those guidelines are now baked into the system and are exactly what federal judges will be using throughout 2026. These are not theory, they are active. States are stacking their own rules on top. Colorado's new permit-to-purchase scheme for most semi-automatic rifles kicks in August 1st, 2026. Other states are watching closely, treating those systems like templates they can copy or crank even harder. Bottom line, 2026 is the year where "I didn't know" is a terrible plan if you carry daily. The NFA tax stamp kill switch. On the NFA side, this is the one change a lot of gun owners are actually happy about. Starting January 1st, 2026, the old $200 tax stamp for suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons drops to $0. But the gear is still full NFA, still registered, still fingerprinted, still photographed, still background checked. The bill passed in 2025 kept the entire NFA structure intact and simply zeroed out the tax for those categories. Machine guns and destructive devices stay at the old $200 rate. Here's how I look at it practically. If I file a Form 1 or Form 4 on or after January 1st, 2026, I save $200 per suppressor or SBR. No cap. If I filed before that date, the law still treats those as taxable, and there is no refund language in the statute. That money is gone. The felony side never changed. Possessing an unregistered NFA firearm is still a federal crime with up to 10 years in prison and a six-figure fine. State law can still wreck your day too. Even with the federal tax at $0, civilian suppressor ownership is outright banned in states like California, Delaware, Hawaii, Illinois, Massachusetts, New Jersey, New York, Rhode Island, and Washington, D.C. So if I'm a concealed carrier driving through one of those states, tossing a can in the range bag without checking the map is a bad plan. The move for 2026 is simple. Treat this as a price cut, not a free-for-all. File clean forms after January 1st, and keep your setup legal in both federal and state columns. The federal sentencing crackdown. This is where things get a lot less forgiving. The U.S. Sentencing Commission's guideline changes that kicked in November 1st, 2025 are now what judges are running with. One of the biggest shifts came out of the Bipartisan Safer Communities Act and later tweaks. Straw purchases and gun paperwork violations now carry significantly heavier penalties. The days of slap-on-the-wrist federal gun cases are fading fast. Here's what that means in plain English. If I buy a handgun for someone I know is a prohibited person, that straw purchase can now land me up to 10 years in federal prison. not 5, 10. Lying on the 4473 is in the same bucket. And that controlled substances question is a trap people keep stepping into. Marijuana is still Schedule 1 federally. So if I'm using illegal drugs under federal law and I check no on that form, I'm stacking charges. ATF and DOJ have openly talked about cross-checking 4473 data against criminal records, drug charges, and even state medical marijuana registries. Once they spot a mismatch, that little lie turns into an easy prosecution. My rule going into 2026 is simple. I only buy guns for myself. I answer every question honestly, and I treat federal gun charges as life-ruining because that's exactly how the guidelines are written. Colorado's semi-auto permit law. Colorado is the test lab. Starting August 1st, 2026, buying a semi-automatic firearm in Colorado means more than filling out a 4473. The state layers a full permit system on top of the federal check. That means a state-approved 4-hour class with live fire before I can even get the 5-year permit required to take possession of most semi-automatic firearms. Rifles, pistols, the whole semi-auto category. Here's where concealed carriers need to pay attention. If I already own my semi-autos before August 1st, they're grandfathered. No retroactive permit just to keep what's in my safe. And if I already hold a valid Colorado concealed carry permit that satisfies the training requirement, that's a small win for people who've been squared away. Where people get jammed up is on penalties. Taking possession of a covered semi-auto without the permit is a Class 2 misdemeanor. Up to 120 days in jail and around $750 in fines. Dealers catch charges too if they ignore the rule. From my perspective, this is exactly the system other gun control states want to copy. So if I'm buying, moving, or traveling through Colorado after 2026, that permit is non-negotiable. Kentucky's new extreme risk protection orders. Kentucky is the one that makes me pause. Starting February 1st, 2026, they activate an extreme risk protection order system. For the first time there, family members, household members, former dating partners, and law enforcement can ask a judge to pull your guns based on an allegation that you're a danger. If the emergency order is signed, you've got 24 hours to surrender every firearm you own. Your concealed carry permit is suspended immediately. No hearing yet. The full hearing comes within 14 days. If the judge agrees, that final order can run up to a year and be renewed. Violating it is a Class D felony. That's 1 to 5 years in prison and permanent loss of gun rights. Even when the order expires, your guns don't automatically come back. You have to petition the court to get your own property returned. As a concealed carrier, that means arguments, breakups, and mental health crises can now trigger a fast seizure system with real felony teeth. You have to live like that tool exists, because it does. Kentucky's new extreme risk protection orders. Kentucky is the one that makes me pause. Starting February 1st, 2026, they activate an extreme risk protection order system. For the first time there, family members, household members, former dating partners, and law enforcement can ask a judge to pull your guns based on an allegation that you're a danger. If the emergency order is signed, you've got 24 hours to surrender every firearm you own. Your concealed carry permit is suspended immediately. No hearing yet. The full hearing comes within 14 days. If the judge agrees, that final order can run up to a year and be renewed. Violating it is a Class D felony. That's 1 to 5 years in prison and permanent loss of gun rights. Even when the order expires, your guns don't automatically come back. You have to petition the court to get your own property returned. As a concealed carrier, that means arguments, breakups, and mental health crises can now trigger a fast seizure system with real felony teeth. You have to live like that tool exists, because it does.